Well, hello everyone and welcome to this session, Copyright and Contract 20 Years On. My name is Ben Rice. I'm the Executive Officer of the Australian Digital Alliance, and I'd like to begin today by acknowledging the Ngunnawal people, who are the traditional owners of the land on which I'm joining you from today. On behalf of the ADA, I pay my respects to their elders past, present and emerging. A few points before we get started. This session will be recorded and will be made available on our website after the forum ends. As usual, I'd invite you to make comments and leave ask any questions in the chat or using the Q&A function. You can also use the raise hand icon and we will prompt you to turn on your microphone and you can ask a question of the panelists verbally. So today, of course, we're here to talk about copyright and contract. It's been 20 years since the CLRC published its report that included a suite of reforms. So what has happened since then? And how does the issue of copyright and contract impact copyright users today? To discuss this, I'm joined by Emeritus Professor Tom Cochrane, Liz Stanton, who's the Director of Copyright Policy at University of Australia, and Margaret Allen, who is the CEO and State Librarian of the State Library of Western Australia. Hello to all of you. Fantastic. Tom, I might start with you. You recorded a pre-recorded presentation looking at some of the history of the CLRC report that people can view on the website if they haven't had a chance to do that yet. But for anyone who hasn't seen that, I'm wondering if maybe you could go over some of the key findings of the report for us before we dive into what's happened since then.
Yes, thank you, Ben, and hello, everyone. So as Ben said, this question was actually looked at in detail 20 years ago. And at that time, the Attorney General was the portfolio that had responsibility for most copyright lawmaking and reviews. So it referred this question to what was then in existence, a Copyright Law Review Committee. And in the presentation, for those that haven't seen it, I'll say a little bit about what that committee was, when it was in existence, what happened after it ceased to exist, and so on. But the key issue was, are contracts in fact being used to exclude or modify the exceptions that were provided in the Copyright Act? And secondly, should that happen? And so these two main points then became four questions. What's the extent of the occurrence of this in the online environment? What's the extent of the occurrence of this in other than the online environment? What is the enforceability of those contracts if they do exist? And then finally, should this situation obtain? Should these things in fact happen? And there was an interesting thing about this inquiry for me, which was that there was some doubt within this panel of experts about whether there was much of a problem. And one reason for that was that some of the early submissions suggested that there wasn't much of a problem. On the other hand, some folk, especially in education and cultural institutions, regarded it as not just something of a problem, but a very significant one. And the evidence came in about that. So the really critical finding was that, yes, we have a problem. And in fact, in its executive summary, the report said that based on its findings, that agreements are being used to exclude or modify the copyright exceptions and that existing remedies are not adequate. The committee has concluded that there is a displacement of the copyright balance. So it therefore recommended, in particular, that action needed to be taken and that the committee recommends that the Copyright Act be amended to provide that an agreement that excludes or modifies the operation of, and then a great string of clauses listing all of the relevant exceptions, has no effect. So that was their very clear recommendation. And There were also some other observations that I made in the presentation. One was that the owner interest and collecting societies in particular didn't have one common view. In fact, it was quite memorable that the CEO of APRA at the time expressed a clear public view about the primacy of Parliament. And I might come back to that point in a moment. There's also been a bit of discussion about whether if you provide that contracts can't be written that have the effect of excluding or modifying the exceptions in the Act, that might have an unintended consequence of excluding greater than the threshold. But that doesn't really hold, because permissions are a form of a contract that enables a greater access, and in fact open content licensing that's what it's all about. So any drafting of any provision would be very clear about that. And the committee itself was in absolutely no doubt about what it was looking at. It was looking at whether the exceptions that provide the environment, the copyright interest, as it was phrased at the time, whether those exceptions could be, as it were, subverted by private contract. And the other thing about the report is it really was a report about law. It wasn't about any particular interests, so it was agnostic about whether it was dealing with libraries, private users, education, and so on. It was really a question of principle. And the other thing that I did draw attention to in the presentation was that we almost immediately hit a jurisdictional issue of interest, which was, since a lot of these contracts, particularly in the online environment, are written in places that are not Australia, what happens about trying to legislate and then enforce the terms of such legislation. So the very first recommendation in the body of the report was that the committee recommended that the government pursue an international solution to private international law issues that relate to these sorts of agreements. So it was considered, although such a review would have been, very interesting and very complex. So the situation is, 20 years later, that no action was taken on the report. It remains an interesting thing on shelves. A lot of issues were looked at. And I personally think that the drafting of it was a very interesting process, but it would be much better if something had happened about it. And that's the situation we're in now. And it's interesting to think that it's still such a live issue 20 years on. So thanks, Ben.
Thanks, Tom. Definitely want to come back to some of those points that you raised there. Before that, I might go to Liz Stanton from Universities Australia to give us a bit of an overview of how the issue affects universities in practice, and to give us a bit of background from the university's perspective.
Sure, thanks Ben, thanks Tom. That was a really good overview of kind of how we got to where we are. And I think from the university perspective, it's difficult that nothing's happened in the last 20 years in Australia, from the CLRC inquiry into how it works and what should probably happen. I hear a lot on my travels around university world that copyright trumps contract, and that if it says you can do something in the Copyright Act, it doesn't matter what your contract says. And that's fraught with a little bit of danger for us, because even though something that you're undertaking might not be an infringement of copyright, you might be breaching your contract. And it becomes a little bit of a struggle when people want to do certain things as to whether they are indeed going to take that risk or not. So really, I think a really good outcome of today is for people to know that when they do sign a contract, to use any of that or any sort of content really, they need to be aware that they are bound by those terms effectively, and that even though the Copyright Act might say that they can do something different, that might not actually be the case. And I think that creates a lot of policy issues for universities, because they pay an awful lot of money directly to publishers for the use of content, that then limits their ability to rely on the Copyright Act to use that content. One of the big ones is interlibrary loans. So there are a lot of agreements that say that you might be able to provide content under an interlibrary loan request, but to do so, you're going to have to print out that digital article or whatever it is, print it out, scan it, send it, and then delete your scan, delete your printout, which is an awful lot of work, and it's very old school. So it really creates a lot of burden for universities, and every agreement is mostly different. So while one agreement might allow you to do one thing, another one might not. And obviously that's an issue for universities, and it's something that the department's touched on, and they will touch on hopefully when we see an exposure draft, because there are other issues that have come up for UA in the past and things that we've commented on publicly where we've talked about, and I think Tom can probably talk more about this later if people want to know more about it, about implications of not having or having certain things in the Act that might say you can't contract out of some things, but it stays silent on contracting out of other things, and the implication that might create. And my understanding is that the department is hoping to clarify that, and to clarify that there is no implication that by saying, like in section 47H, you can't contract out of this specific thing, doesn't imply that you can contract out of other things, which will be a really amazing thing for universities to have that clarification, I think. So that's really all I wanted to say for now. I'm more interested to see what people want to know in the questions. So I might mute and wait for that.
Thanks, Liz. And yes, I mean, touching on some of the things you've said, we can definitely circle back around to that. But I note that there are some other jurisdictions that have more recently adopted similar changes to those that the CLRC recommended. So in 2014, the changes to the UK copyright law that included protections for contractual override. And last week we were speaking with Trina Ha, who joined us from the Singapore Intellectual Property Office, and their draft copyright bill includes some protections there for contractual override as well. Margaret, thanks for joining us. I'm wondering if you might be able to step us through some of the perspectives and considerations from the library sector and some of the issues that you've come across.
Yeah, thanks, Ben, and hi, everyone. And as we start, I'd like to acknowledge that today I am on Whadjuk Noongar land, and I pay my respects to elders past, present, and their continuing culture and connection to land, sea, and country. The question, yes, are contracts being used to override library exceptions under Australian copyright law? The simple answer is yes. And I like Tom's term that our rights are subverted. I think that appeals to the rebel in me, I guess, around that's a fabulous term that we could use. And I think it's really sad that 20 years later, as far as I can tell, we're actually in no better position. But I think it's worth reflecting that in 2002, libraries were still very much dealing in a print environment. Okay, yes, there was digital, but if you look at the change in the materials that we're dealing with, it's like a multiplier effect, because actually in 2002, the issues were around a smaller portion of our collections. These days, it's the majority of our collections, so the impact is much, much bigger 20 years on. Even though the issues are the same, I think the way it's impacting us. So the sort of the areas where we find it most common that our rights will be subverted are, of course, around our ability to use the fair dealing provisions under the Act. And remembering it's not just the contract, it's the digital rights management and the technologies that these vendors also use to ensure that those rights are overridden. So it's a double whammy. It's not just the contract, it's the mechanisms that are then used to enforce the contract. So most contracts together with the technological protection measures, severely limit printing. So it's very difficult to print. Often you'll have to do a page by page print if you want to print something. You can't print a range of pages or an article, which of course, you know, under fair dealing that you may be allowed to do. Similarly for downloading. Often, Liz has already mentioned interlibrary loan and document delivery. That's severely restricted. To enable us to do that, the processes are really manually intensive. They don't make sense. And that's one of the other issues that we continually deal with, our users' expectation of the way in which a service can operate in a digital environment. Often we're forced to go back to an analog environment and turn it into a hybrid digital delivery. And so the type of service and the level of service doesn't meet our users' expectations. And then the other one, of course, is, which has been even more of an issue in the COVID world, is that many of the contracts and the associated TPMs limit access to resources from just the physical library building. That's difficult enough when you're in an environment where some people can come into a building, but coming from Western Australia, a person from Kununurra can't easily get to our reading room to get to a resource. But in a COVID world of working from home, of studying from home, when the library is physically closed, that makes absolutely no sense. So, you know, all of these, whilst it can be simply seen as a subversion of a right under the Act, the practical implications and the implications on a user are really significant. The other one that we often come across is an expectation that libraries will actually enforce the sort of rights, the right holders' rights on every user that uses the resources. So sometimes we get contracts that say that the library will guarantee that a user won't use it for these particular purposes. Now, we're all used to having the sign by the photocopier that says, here's the Copyright Act, here's, you know, what you can and can't do. But in a digital world where a contract is presented that says you will guarantee that none of your users, you know, use it for commercial purposes or, you know, don't do it other than fair dealing, it would actually literally require us to stand over every user, which is just completely impractical. It's also a privacy issue. So these are the sorts of clauses that we commonly are presented with in our contracts. The one that I think we probably haven't tested yet would be format shifting under the Marrakesh Treaty and the recent amendments to the Copyright Act. I don't know yet of a library that's had to actually deliver on an alternate format, and just how easy that is, how the contracts sit and what the technological protection measures are that would enable us to fulfil those rights. And as Tom has mentioned too, many of our contracts stem from overseas, so they just completely ignore Australian copyright law and jurisdiction. So for libraries and, you know, particularly the NASLA consortia partners, we try not to enter into contracts like that. We try and push back and say, look, this is, you know, what we're looking for. Sometimes we're successful with that and sometimes we're not. We try and walk away wherever possible and say, well, no, we won't, you know, license that resource. But in the end, it's the user that suffers, and sometimes we do make decisions around accepting subverted or compromised terms to enable provision of a resource. And often that's in a situation where there's a monopoly on the provision of a particular resource or set of resources, or we can't find an alternate version. And all of this is incredibly time consuming, and Liz mentioned that many libraries, you look at public libraries, many of them don't have access to legal advice. It's costly, it's time consuming, and there's a power imbalance. So many libraries just tend to take the contracts as they're presented because they want to provide the resources. I think probably one of the most recent examples, and one that I think personally is particularly concerning and is of a great deal of personal frustration, is access to Australian standards. Now, Australian standards are used in a whole lot of situations, including written into legislation. So there are Australian standards which are legal requirements, and that's often in the areas of safety, building standards, product standards, COTS. There's a whole range of consumer and other legislation that require standards. Taking the principle that in a democracy, citizens should have access to the laws that affect them, it's very frustrating that the average citizen can't get in an easy way to an Australian standard that's written into a law. And Australian libraries can't easily provide access to those standards either. So since September 2018, national and state libraries have not been able to provide access to Australian standards. There's a bit of background to this that I won't go into, but other than to say, despite NASLA's best efforts, we haven't been able to negotiate what we consider an acceptable licence with Standards Australia or their providers. There's been a reluctance to negotiate around terms. So the latest licence version that we were presented with would mean that we couldn't do document delivery or interlibrary loan, a digital copy of a standard. Access was restricted only to the reading room in each capital city. There was no remote access. And the fair dealing provisions of being able to download part of the standard or print off some of the standard were severely restricted to say that pretty well didn't exist. So NASLA walked away and basically said, you know, we can't, it's not acceptable, we can't provide access to standards under these terms. And that continues to be incredibly frustrating because there is significant taxpayer investment in the creation of Australian standards. They are, some of them, required under law. Citizens don't have access to the laws that affect them. And then, of course, the COVID working from home situation would have made the licence agreement completely useless because our capital city reading rooms would have been closed, but we couldn't provide remote access. So it's incredibly frustrating. If we had protection around the exceptions under the Copyright Act, at least we'd be able to provide document delivery, people would be able to exercise their fair dealing rights and be able to, you know, print the relevant bits that they need or easily get access to it. So it's, I think it's one of those really important examples that we should continue to use in our lobbying. There's in my view, a failure of government policy in relation to access to Australian standards, and there has been for quite some time, but we're in this completely unacceptable situation. It's been the subject of a WA parliamentary inquiry, and it's interesting to note that even parliamentarians can't get to standards to have a look at the impact on the legislation that they're reviewing. So if our parliamentarians can't scrutinise the legislation, you know, where does that leave us? So it's completely unacceptable. And to take Tom's point too, as I understand it, it's not just an issue for libraries with Australian standards. If you buy a standard personally, there are restrictions on printing and all sorts of things as well. So it's not just a library issue in that regard. So having said that, it's not all bad news. I have to say there are a number of vendors during COVID that have been really helpful and supportive under our current licensing agreements and have allowed remote access, have been more flexible, and that's great. And to me, it shows that it is possible and the vendors aren't too concerned about their revenue. They don't see that that sort of access was going to have a negative impact on their revenue. So hopefully that can be used as a positive example for other vendors to think about what they're doing. And also through the National E-Deposit Service, the collaborative NASLA and National Library Legal Deposit Service, we've been really pleased to see an increasing number of publishers who've deposited materials, enabling and are actually giving permission for full access via the internet from the time of deposit. So that's really good. There are changing views in the community, changing views from publishers around access to material, and that's really great. So, you know, really important, I think, that the ALCC and the ADA continue to advocate to protect the library and archive exceptions from contractual override. And to go to a point, you know, why are the rights of libraries and their users considered less important than the rights holders' rights? Because that's what it comes down to. They're saying that the rights holders' rights are more important and they can contract them away as opposed to the rights that we have. So I'll leave it there.
Thanks, Margaret. A couple of really great examples there. I want to make sure we've got a couple of questions coming in, so I want to make sure everyone, just as a reminder, to please post your questions in the comment box or the Q&A box, and feel free to use the raise hand function as well, and we'll prompt you to turn a microphone on. A couple of things, Margaret, that you mentioned there is the impact of COVID and people not being able to get access to services that are provided through the library or libraries around Australia for various reasons. And I think that's been sort of one of the key themes that we've been talking about in the forum so far, is that, you know, the lack of access that people have experienced because of COVID. But going back to the point that these problems existed before COVID and will continue, you know, after COVID, and are just more broad access issues that COVID's done a lot to highlight, but that we need to address going forward regardless. Tom, I wonder, and Tom and Liz, one of the things that Margaret talked about was the increasing number of digital resources in collections. Tom, when the report was first written, when the CLRC was first looking at this issue, what was the balance like between the physical and digital resources? Obviously, there are a lot more digital resources in collections now, but was that an issue back then that the CLRC addressed in the report?
Yes, look, Margaret's quite right. The universe of digital works has just become, you know, much more substantial. However, in 2001, especially in university and research institutions, most of the really significant scientific and technical literature, and in fact the journal literature in the social sciences, was arriving not just electronically, but quite often in bundles, large bundles. And these are the things that came with these contracts. So when the public forum was held as part of the review process in Sydney, one of the questions that, or, you know, the members of the review committee were there, one of the questions was, you know, please tell us how much of a problem this is. And people couldn't wait to get to their feet, including people with jobs like solicitors advising within university administrations about the various things that the university had to deal with. So, you know, that the evidence the suggestion that maybe this isn't much of a problem, or if it is, doesn't need to be dealt with a fully fledged review, that really disappeared quickly. On the matter of, are there examples of this in the non-digital environment? Well, the answer was yes. Yes, there were, but it wasn't coming to the table with any kind of urgency because people could see what the trend was, that this was going to apply, this contracting to a threshold above that provided by the legislated exceptions and limitations was arriving like a steam train. And that's why people wanted to have it looked into in that way. Can I just make one more comment too about something I said I'd come back to, which was what the CEO of APRA said in that same public forum about the legislative environment, because I've thought a lot about that since then. And we have to remember that copyright it's a complex provision into which a great deal of thought went when it was first being considered, to provide recognition, reward, and further encouragement to those who would be authors, creators, etc. But at the same time to seek to support the advancement of learning and access to works as a public good. And that was a development that then had to be crafted or represented by crafting the law as giving an author a monopoly, but making it quite clear that there were exceptions and limitations to the exercise of that monopoly. And all of the debates that we've had over the 300 years since, have been about what those limitations and exceptions are. So if you have a trend where that becomes irrelevant because you can capture a large part of the owner and user transaction in private contract, then the original intention seems to not be worth all the effort. So that was the thing that was motivating that comment, I think. And one of the questions that's come up about barriers to addressing issues, that's a really good question. Where the government has conducted many reviews of copyright law, not just this one, many, especially the Australian Law Reform Commission, the proposals for which were tabled in 2013. And why they don't get acted on, what the barriers are for them being acted on, is not something that's necessarily transparent. And it's likely to be different things at different times. Thanks, Ben.
I might just add to that, Tom, as well. I completely agree with you. And in response to that question, it's obvious that the government recognises that there is a need for clarity, because they've mentioned it, and they've mentioned that they know that something needs to happen. But the concern is, will it? Or will a similar thing that's happened in the past happen again? An optimistic person would say, hopefully we're going to get some clarity in this process beyond what Section 47 says.
Yeah, thanks, Liz. And to circle back around to one of Margaret's points and Tom's first point there about the comparative situation between digital and physical items in the collection. Does that mean that the problem now is worse for universities and libraries, which seems to be what Margaret is saying, than it was 20 years ago when the focus was more on physical material?
From a uni perspective, I don't know that it's worse, because, as Tom said, there were still restrictions in the print environment. I mean, my understanding is that there weren't as many restrictions as there are in the digital environment, and it's not quite as, I think there are probably more contracts floating around now, maybe, than there were before. And in particular, when it comes to digital contracts for digital content, they're pretty much all different. So chatting to Call about this recently, my dear friends over at Call, and I was just asking do you know off the top of your head, how many of the Call contracts have something in there that contracts you out of, or contracts a university out of something in the Copyright Act? And they're like, oh, I don't know, it happens probably more often than not, and it's probably more common in those agreements, but we would have to go through every single agreement to check. And that just comes back to what Margaret pretty much backed me up on there, that it's really time consuming to go through and know which agreement allows you to do which things. And I get a lot of inquiries from universities where things are really, they're not clear either. I had one recently from a uni who I think is actually on here, so she can correct me if I'm wrong, but it was with a UK publisher, I think. And it talked about being able to contracting you out of the UK and the US acts, I think it was, it was an older agreement. And the question was, well, does that mean that we're contracting out of the Australian acts as well by entering into this agreement? So there's a lot of confusion, and it makes it hard, and it's an awful lot of work to sift through. And we have major problems with Standards Australia in the uni sector as well, and things that the ACCC has commented on, saying, how can you possibly expect people to be able to create safe consumer goods and not have to recall so many items that they've built if they don't have proper access to the standards that they must adhere to? So they're pretty big issues. Contracting out seems so small, and when you look at the Act, it's just this tiny little mention in 47H, but it's actually got such a huge knock-on effects for libraries and for universities.
Yeah, and look, I think it's the history of this and its impact is a little different in each of the sectors. And certainly in the early 2000s, the universities, as Tom rightly points out, there was a large amount of digital content in the serial and journal areas for public libraries, for school libraries, for even state and national libraries. The move to the e-book, where so much of our content is coming now in digital form. And it's the multitude of contracts, it's the multitude of vendors that we're now dealing with, and having to understand the nuances of each contract and work through those. The actual issues haven't changed. For me, it's the impact on our day-to-day operation that's really bringing this to the fore. And as Liz said, it seems relatively minor, but the impact daily is very significant on libraries and on our users. And COVID has just, accelerated that as well.
Ben, I think the one comment I'd make is the problem in general has grown with the volume of material that's governed, that the access to which is governed by these contracts. Conversely, I think that libraries in particular have become more canny in terms of trying to negotiate terms which would be more appropriate. But that isn't just about whether there's a conflict with exceptions, it's about other things as well. I mean, it's not an area that lacks complexity. One of the things that became pretty standard with licensing as electronic material grew was that licenses were signed to provide in the academic sector access to students and staff at the institution. And it was in that sense it resembled software licensing and many other forms of licensing. There's an interesting question that then arose about that, which was, well, what happened to previous arrangements where someone could walk in to a library building and at least see something, which now they couldn't see at all. And some libraries sought to solve that problem by having specific licenses negotiated that provided that. But that's also something that can change by jurisdiction. It was very interesting to me to see that in the US, if a university sought to exercise a discretion which limited access in the physical world to its students and staff, that could be challenged on the basis of being a subversion of state taxpayers' rights. And in fact, that there was quite a live debate about that. It's rather different to here. So there are neighbouring issues which any crafting of something that would change this needs to be aware of.
Thanks, Tom. A couple of other questions coming in. So one here, that the contracting out issues seems to be pinned mostly as affecting libraries and archives, and I'd add the education sector to that as well. The question is, isn't the legal reality that this affects private citizens too, considering that most material is accessed digitally? I wonder if anyone has any thoughts on that. I mean, it certainly seems to be users of material that are most affected.
Yes, well, as click wrap and shrink wrap grew rapidly, some of the best copyright minds in the US became very concerned about the way that was, in fact, changing the copyright balance. Click wrap and shrink wrap licenses, of course, are absolutely pervasive now. And I suppose that one has to, in order to sort these issues out, one has to navigate this by thinking about those licenses which are really about things that are covered by the Copyright Act and those which are not, those which are essentially amount to the use of a consumer material or whatever.
Thanks, Tom. Liz or Margaret, did you have anything to add on that?
Not particularly, other than to agree it is not just an issue for libraries, the education sector and archives. As I said, it's my understanding, even if you buy a standard personally, there's TPMs and license agreements that restrict you from exercising a fair dealing use of that material. So.
Another question that's come in here is, did the
Ben, I was just going to say, I do have something to add. I always have something to add. You know that.
Please go.
And I'm going to be that person who takes it too far and answers the question with a question. But there is possibly scope to question whether these sorts of things might have an impact on certain human rights and access to information, access to education, things that are inherent. And if you're stopping people's access to those sorts of things and preventing us from being able to undertake things that the Copyright Act says that we can undertake for the purpose of balance, user rights holder, user balance, and making sure that people do have access to information, and making sure that they do have access to education and access to, as Elliot has said in the chat, to culture. There could be a question of whether these sorts of restrictions are impeding that or those rights. I don't want to be the person who says they are, but I would certainly like to be the person who asked the question, I suppose. Something to think about.
Can I comment on a couple of the other issues that have come in the chat? So the question of when contracts take effect, I don't remember the committee specifically considering the issue of duration or the nature of contracts. It was really the question of whether a contract for providing access to material had the effect of overriding an exception or limitation. And of course, general website terms and conditions and so on, they were starting up then, but they've grown rapidly. I think the committee's main concern was a kind of general principle of law. As I said before, it was agnostic whether it was talking about libraries, individuals, education, government departments, whatever. It was a principle about whether private contract would be able to undermine the provision that was provided in legislation. The question that's come in about authorised user definitions, but there's a whole neighbouring issue there about access to publicly funded research, which we know about, which is in the sort of open access space. And if there's a convergence between that question and general copyright questions, it's the way that debate has developed, and to some extent consensus has formed about the application of open content licensing to refereed research outputs. But that's really another topic, and it's certainly, that wasn't a mature discussion at the time that the CLRC did its review of the question.
Yeah, thanks, Tom. One of the things that you mentioned earlier on, and I think you touched on in your pre-record, was the jurisdictional issue. So I've got a couple of questions. The first one is there anything that can be done about those sorts of concerns? And not so much a jurisdictional question, but more pulling on international examples. The UK has introduced protections for contractual override in 2014. I'm wondering if anyone on the panel has had any contact with other jurisdictions that have these protections and how they've been operating in practice.
I haven't been. I was particularly interested in that issue when it came up because of the committee recommendation that it required that further expert work. I don't know whether within the Attorney General's Department at the time or anywhere since a think tank was set up or someone thought about it and investigated what might happen, whether it was ever pursued in any other or parallel kind of forum with international interest, because I think it would be really interesting. It like everything else that was recommended in the report, it was just silence. Oh, there was a statement, I should correct that. There was a statement that the government would consider the report and advise what it would do. And my memory is that didn't, we didn't hear subsequent advice about what it would do.
Thanks, Tom. Margaret or Liz, anything to add on the jurisdictional issue there, or any of those international examples that you might have heard of, come across?
No, and I must admit it's not a topic that I've particularly explored with colleagues. overseas. But I guess to me, it just reinforces the point that we're dealing with vendors from a whole range of countries and different jurisdictional arrangements. So it adds to the complexity for them, but it also adds to the complexity for us in understanding where a contract's been written and what might be behind it. So yeah, not really a lot to add.
Liz, I'm eagerly waiting for you to jump in there, but not this time. Okay, so we've got a comment that's come through as well, saying it's perhaps interesting to note that the GLAM and education sectors have had much more success getting the government to address the digital lock issue, i.e. TPMs preventing users from relying on exceptions, than they have getting the government to address the contractual lock issue, i.e. contractual terms themselves purporting to prevent reliance on exceptions. Anyone like to comment on that before we jump into some more questions from the panel, from the floor?
Well, I think the success there has been in the preservation space, that, you know, without the ability to actually preserve this material, it's lost forever. So I think that argument's had resonance, and you know, but yes, this is one of these issues that I think that the rights holders, maybe they're continuing that argument that there's not a problem, despite the evidence that's been presented. So it's really just trying to make sure that we keep saying there is a problem. There actually is a problem. Nothing really has changed since 2002.
Yeah, and it certainly seems that both from the library and the education sectors that there certainly is still a problem that exists. Liz, I can see you.
I'm just trying to decide whether to say this or not, but I think you're right, Margaret. I think it is there's nothing to see here kind of thing, which is really unfortunate because, as you said, there is obviously something to see, and it's impeding our ability to do our job, really, for at least universities as educational institutions and research institutions. It is making it really hard for us to provide quality content to people, and especially COVID has highlighted that. And as COVID hopefully starts to die away, I fear the issue might as well, which will again be unfortunate. So yes, you're right. The discourse must continue, and we must continue to remind people how difficult it is, and the expense and the administrative task of trying to manage all of this is huge. Even in small institutions, it's huge.
Yeah, and at the risk of sounding like a broken record, because I can't count how many times I've said this over the last 2 weeks and over the last couple of months, but you know, these issues, COVID wasn't the first time that these issues arose. It certainly brought them to the fore, and everyone's hyper aware of them now. But they won't go away when we all return to normal life, or a COVID normal. You know, the trend towards digital access and online access to material, and people not just having an expectation for that, but really relying on it in a lot of ways. You know, as Margaret said, libraries in Western Australia, God knows how long it takes, you know, for some users to access that material physically. You know, it's not just a COVID issue. It's an issue of equity for people who don't have easy access, you know, to that sort of material. I'm lucky enough to live in Canberra, where there are countless cultural institutions, you know, only a short walk away. But it's not entirely fair that people should be forced to travel all the way to Canberra to get to experience. You know,
and in the case of Australian standards, the National Library is a legal deposit library for Australian standards, but the State Library of Western Australia isn't. So, you know, it's a double whammy that some jurisdictions, it is much easier to provide the physical access. And I think often that's the focus. Oh, look, I can just walk to the National Library and get it. Well, that's fine if you live in Canberra. It's not fine if you live in Kalgoorlie or Kununurra or Tennant Creek or Katherine, or, you know, so it's part of that challenge around the capital city centricity of often political debate and perspective. So, yeah.
Yeah, it's definitely one of the most exciting parts of the copyright reforms that that are underway at the moment, and that we're hoping to see more of soon. You know, is that ability for people to access this material, you know, without having to live close by, you know, even after we get out of a pandemic. We've got just under 10 minutes left, and I want to make sure that everyone gets a chance to ask a question. We've got another one that's come in here saying we may get fair dealing for non-commercial quotation, yet we'll have to all consult our license agreements in the first instance for contracting out first. Very unsatisfactory compared to the UK. More of a comment, but I'll throw to the panel to anything they'd like to add there.
I'll just make the comment that any revival of lobbying on this issue to try and get it addressed, and at least get some greater attention explicitly paid to the recommendation that's still sitting there about all this, would be to be looking at other jurisdictions which have tried to tackle it and done a better job. In this case, the comparisons with the UK. It's just a comment on the comment.
I'll make a comment on the comment too. Sorry, Margaret. My comment on the comment is that's pretty much what I was saying at the beginning. I think in the uni sector in particular, I think there are a lot of cases where we just don't know what we've been told to contract out of in our contracts. And yes, if there are changes to the Copyright Act that don't include something significant to contracting out, it will require us to go back through our contracts and make sure that we're aware of what they say. And it will be interesting to see what starts coming out in them. If these reforms are successful, it'd be interesting to see how contracts are rewritten in the next few years, if, as I said, if the reforms are successful. It's a big task.
No, look, I completely agree with the comment. The only thing I would add is, for me, this just underscores how important it is that we keep on advocating and keep on lobbying, and don't just let there's nothing to see here. I think without the ADA and the Australian Libraries Copyright Committee, nothing would change. It would be there is nothing to see here, and we would just continue to be restricted in what we do and how we can do it. So to me, it just underscores why we have to keep going at this.
I noticed the questions come in to us in the Q&A segment about betting the farm. I suppose I can't wriggle out of that by saying I don't have a farm. One lives in perpetual hope in this space. And sometimes things seem to get a bit more balanced. But it is quite frustrating to see really good work by the best minds. You know, I'm talking about legal minds, people whose whole career has been copyright law, just sit wasting, as it were, unattended. And the response quite often being a cycle of further reviews, which then have the same fate. But in the long term, I think that the pendulum really had swung too far in the kind of 90s, early, in the first panic about what to do about the way content was more readily available on the net. I think there was significant legislative overreach in many jurisdictions, and I think that there will be a recovery from that at some point in various ways. So yeah, I'm hopeful that this issue will get looked at again, just as I'm hopeful that a regime which is more flexible, such as fair use, will get a decent look. And in fact, that, one way of being a bit optimistic about the farm is to look at the fact that in some jurisdictions there has been some pretty good thinking and legislative improvement. I'm thinking of Singapore as an example.
Going to open my mouth cautiously. I read an article today that one of my dear colleagues sent to me that was that 3 reasons that Israel is better at commercializing research than Australia, I think was the title. And they probably missed one, which is fair use. Wasn't mentioned. Nobody thought to think about it. And that is frustrating because, Tom, I agree with you. I think the pendulum must swing back to the middle at some point, and fair use would be a magnificent way for that to happen. Regarding what's proposed now, my words are cautiously optimistic, and I have faith in the department, and I think what they're doing is really great, and they're really intelligent people who are working really hard on this. And I think that's what that's me.
I'm always optimistic. So, you know, we need to work with and through the process, have our clear arguments and evidence. And as Tom said, there's been some much more capable legal minds than mine given to this. So much of that is on the table. And so we need to use it, keep using it, keep drawing attention to it. But I am optimistic. We have achieved change in recent years, you know, but it's not a once-off process. It's something that just has to continue and is iterative. And we, you know, try and get movement in one area and then we focus on the next. So yeah, I am optimistic.
Thanks, everyone. We've got just 3 minutes left. So if there's anyone who wants to ask a final question, please do feel free to jump in now. But we will try and wrap up bang on 2 o'clock. There are a couple of options of a way forward. One of the options that's been floated is the idea of clarifying that Section 47H doesn't imply a statutory assumption that other exceptions are to be protected from contractual override. Liz, earlier you said you thought that would be a great step forward and seemed quite supportive of that. Tom, I wonder if you had any comments on that just before we wrap up, and Margaret quickly, but that seems to be the most likely way forward. So just wanted to get your thoughts on that.
Look, any way forward is better than where we are now, Ben. But one would have to look at the effect and the intelligibility of the provision. I mean, one of the things that often happens with this, in this area of law is that people, most ordinary people, find it extremely difficult to unravel the section. So, provided that whatever is done that has a beneficial effect is clear, then I would be supportive.
Yeah, and Margaret, finally, I guess just to go to the practicalities of it.
Yeah, I don't really have much else to add. Like Tom, I think it needs to be unpicked and have a look at all of the implications, but I'm sure that could be done. Well,
thank you all so much for joining us, Liz, Tom, and Margaret. I think it's been a really interesting session. Just one final comment, still optimistic in the comments section there, and I think we all are at the moment, feeling a sense of optimism that there will be some really positive progress around contractual override going forward. So thank you everyone for joining us. Thank you to our panelists, Liz, Tom, and Margaret. Thanks to everyone who asked questions and for tuning in. We have another session of the forum tomorrow looking at open access, and that is at 1 o'clock. So look forward to seeing as many of you there as possible. Thanks, everyone.